Imagine you're driving to get tacos, minding your own business, and suddenly another car runs a red light and slams into you. The airbag doesn't go off, or worse, it explodes like a confetti cannon full of shrapnel and makes everything 10 times worse. Here's the twist nobody tells you at the car dealership. The thing designed to save your life can actually be the thing that hurts you. When that happens, you're not just dealing with a car accident anymore, you're dealing with something called a product liability claim. Product liability is basically the legal world's way of saying a company made something dangerous, and now they have to answer for it. It sounds fancy, but think of it like returning a broken toy, except the toy was a car part and the return process involves a courtroom. There are 3 main ways a product can be legally defective, and this is where it gets interesting. You've got a design defect, a manufacturing defect, and a failure to warn, which sounds like a band name but is actually a very serious legal category. A design defect means the whole blueprint was bad from the start, like every single airbag of that model was a ticking time bomb waiting to happen. A manufacturing defect means the design was fine, but something went wrong during the assembly, like that one Monday morning at the factory nobody wants to talk about. Failure to warn means the company knew something was sketchy and just quietly hoped nobody noticed. Takata, the airbag company that became infamous for sending metal shards flying at drivers, is basically the poster child for all 3 of these at once. So how do you actually sue a manufacturer? First, you need to connect your injury directly to the defective part, which means preserving every shred of evidence you can get your hands on. Don't repair the car, don't let the insurance company quietly crush it, and document absolutely everything with photos, medical records, and witness statements. Think of the car as a crime scene, because in the eyes of the law, it kind of is. This is exactly where an accident injury lawyer becomes your best friend, your translator, and honestly, your project manager all rolled into one. They know how to bring in accident reconstruction experts, engineers, and product specialists who can testify that yes, this thing was defective, and yes, that is why you got hurt. These cases can name multiple defendants, meaning you could be going after the manufacturer, the parts supplier, the dealership, and sometimes even the mechanic who last touched it. It's less like pointing one finger and more like pointing a whole handful of fingers in slightly different directions. You might be wondering if the car being recalled changes things, and the answer is yes and no. A recall actually helps your case, because it's basically the company admitting the part had a problem, but you still need to prove that specific defect caused your specific injury. Statutes of limitations are real and they are not messing around, meaning you only have a certain window of time to file your claim before the law basically says, sorry, too late. In most states, that window is somewhere around 2 to 4 years, but it varies, so waiting around is genuinely one of the worst strategies you can pick. The good news is most accident injury lawyers take these cases on contingency, which means you pay nothing up front and they only get paid if you win. That's the legal world's version of a no-win, no-fee handshake. And it means pretty much anyone can access this kind of representation, regardless of their bank account. At the end of the day, manufacturers have entire legal teams whose job is to minimize what they pay you, and you deserve someone in your corner who knows how to fight back. Your seatbelt or your airbag was supposed to protect you, and if it failed, that's not just bad luck, that's accountability waiting to happen. If you want to learn more about how our company helps people just like you navigate these kinds of cases, check out the links in the description below.